So we just had an election in Florida where Governor Ron DeSantis essentially declared himself exempt from state laws that are supposed to stop government officials from using their authority and their official positions to interfere with state elections. This is a big part of how the governor defended his decision to spend millions of dollars of taxpayer money on political ads against those ballot measures that would have overturned the state's near total ban on abortion and legalized recreational marijuana in Florida. This was an utterly absurd legal position. And yet, Florida's courts, which are supposed to be an independent branch of government that serve to check the governor when he goes too far, refuse to do anything about it. How did we get to the point where Florida's courts, particularly the state's highest court, the Florida Supreme Court, have essentially become lapdogs for the governor and the legislature? Well, it's the result of a deliberate and decade-plus long effort to roll back laws that were supposed to protect the independence of the state judiciary. We're going to talk more about that today, and we're going to do it with a guy who knows this story better than anybody. Stay tuned. Hello, and welcome to Seeking Rents, the podcast. I'm your host, Jason Garcia. I am the publisher of Seeking Rents. That's a newsletter in Florida about state politics, but with a particular emphasis on the ways big businesses and other special interests influence public policy in this state. That name, Seeking Rents, comes from a term in economics called rent seeking. And rent seeking is what's happening when someone with lots of wealth and influence, like a big business or a billionaire, uses that wealth and influence to get laws changed in their favor in a way that allows them to capture even more wealth and influence for themselves, usually at the expense of someone else. So my guest today is a guy who's seen some things. Martin Dyckman spent nearly 50 years with the Tampa Bay Times, back when it was still called the St. Petersburg Times, the St. Pete Times, a name which it never should have changed, by the way. Anyway, Martin was the paper's Capitol Bureau chief from, get this, 1969 to 1976, before later moving on to editorial and opinion writing. He's actually still writing editorials today, in fact, but now as a member of the editorial board at the South Florida Sun Sentinel. Anyway, I wanted to have Martin on because he's pretty much the authority on the history of Florida's courts. Back in the day, his investigative journalism helped lead to the resignation of two corrupt Florida Supreme Court justices and triggered a sweeping set of reforms that, at least for a time, helped restore integrity and independence to the state courts, particularly the Florida Supreme Court, the highest court in all of Florida. Martin wrote the book on this stuff, and I mean that literally. It's called A Most Disorderly Court, Scandal and Reform in the Florida Judiciary. Now, all of these reforms came about back in the 1970s, and they stood with bipartisan support for more than 3 decades. But then Florida Republicans set about systematically dismantling many of the most important changes. This began under Jeb Bush, then Rick Scott went even further, and now Ron DeSantis has gone even further still, to the point where we now have a Supreme Court that, I would argue, has basically abandoned its role as an independent branch of government and a check on the governor and legislature, and instead become a rubber stamp for the governor and legislature. Let me say that part again. It began under Jeb Bush, then Rick Scott went even further, and then Ron DeSantis went even further still, to the point where we now have a Florida Supreme Court that, I would argue, has basically abandoned its role as an independent branch of government and instead become a rubber stamp for the governor and the legislature, and a roadblock to anybody who tries to challenge them. It's gotten so bad that we just had an election in which Ron DeSantis declared himself essentially exempt from state laws that are supposed to stop government officials from abusing their office to interfere with elections. And the Florida Supreme Court refused to do anything about it. So I wanted to have Martin on the show to talk about it all, both because I'm genuinely curious to hear his thoughts on this stuff, but also because I think it's really important for anybody who cares about Florida to know some of this history and to understand how we got to where we are today with our state government. Before we get to it, just as always, if you're watching this, make sure to click the like and subscribe buttons, and please leave any feedback or comments below, particularly if this conversation strikes any thoughts with you. Okay, let's get right to the conversation with Martin Dyckman. Martin Dyckman, welcome to the show.
Thank you for having me.
Yeah. Thank you for doing this. I know I explained this to you a bit, but just so listeners have some of this context, part of what prompted me to reach out to you is just watching everything unfold with the Amendment 3 and 4 campaigns this year specifically, where we saw sort of just an utterly unprecedented use of state resources by the DeSantis administration to essentially campaign against these amendments, which would have, overturned the state's abortion ban and legalized marijuana. And there were a bunch of legal challenges filed around this, and repeatedly, every state court that got asked to step in refused to do so. They almost always found some sort of procedural reason to not get involved or to deny petitions challenging stuff, often in ways that allowed DeSantis to continue doing whatever he was doing without ever addressing the sort of underlying issue. And the one example that most jumped out at me is there's a law in the books that prohibits state officials from using state resources to wage political campaigns. Seems like a pretty bright line to me. But the DeSantis administration took the position under a, shall we say, debatable reading of the statute that they were immune from that statute. And this goes to someone tries to challenge this with the Florida Supreme Court. The Florida Supreme Court just refuses to get involved and doesn't even rule on whether or not the DeSantis administration is immune from it, which, of course, the practical effect is that, they may as well be immune if nobody can enforce this law. And so that got me thinking about how the courts seem to have sort of fundamentally abdicated their responsibility in Florida, or their role as a check on the executive and the legislative branches. But before I dive into some of the history, I'm just sort of curious your take. Am I being too aggressive, do you think, or what's your sense of how the courts have
No,
behaved?
I think you've effectively described what's going on. The Florida courts and the appeals courts in particular, which include the Supreme Court, have essentially been turned into functional arms, wholly owned subsidiaries of the governor's office.
Right.
And this gets to the most tragic development I've seen in Florida in all the years that I started covering it, which went go back to the 1950s. The Governor Askew, elected in 1970, was a last practicing lawyer who became governor, and he cared very strongly for the courts. He was aware that the outgoing governor, Claude Kirk, had just appointed a Supreme Court Justice, David McCain. The Florida bar had tried to block as corrupt. Governor Kirk didn't want to hear that, and of course, McCain did turn out to be corrupt. But Askew voluntarily initiated what he called merit selection. That is, whenever there was a vacancy in any of the courts, rather than just appoint anyone he liked, he would call on these nominating councils, as he called them, now they're called commissions,
Right.
to recommend at least 3 candidates for every position. And he committed himself to choosing no one else.
Wow. Can I just interrupt you just to make sure sort of I understand and folks understand? So at that point, the sort of right as Ruben Askew was becoming governor in the early 70s, did governors have like complete freedom? They could just pick whoever they wanted for like the Supreme Court or for appellate court or court?
Well, there's no joke that parody definition of a judge, a noun, a lawyer who knew the governor. Askew voluntarily gave up his power to do that.
That's amazing.
McFarland, who was an executive of the Florida bar and a Republican who had represented Republican causes in court, said to me that this was the most unselfish thing any governor ever did.
That's remarkable.
For under Askew, it worked beautifully. It worked beautifully because he told his people to keep their hands off the court, the nominating commissions. He would not interfere with them.
Wow.
No,
and so
he admired nobody. Yeah.
And just so I make sure, so what the governor first did, he sort of voluntarily agreed to be bound by nominees supplied by the Florida bar. Is that right?
No, not by the Florida bar. Each nominating commission consisted of 9 members. The governor would appoint 3 of them. The bar would appoint 3 of them. That's not a majority for either side. Once seated, those 6 members of each commission would advertise for lay members from the public, and they would appoint them. So they would balance out their membership with three members chosen for the public. Now, I will not suggest that this completely excluded bar politics.
Right.
Bar politics are very powerful, but it did pretty much minimize partisan politics. Askew hardly knew any of the first three people he appointed to the Supreme Court. And when former Governor Leroy Collins, whom Askew admired intensely, applied for one of those vacancies, he could not even get an interview with the commission.
Oh, wow.
I read letters that his friends wrote to him saying, we can't get to the governor on this. We can't get past his staff. They won't listen to us. That's how seriously Askew took the independence of the courts. All that changed in 2001 when the Republic.
Yeah, and before you get to that, so Governor Askew voluntarily agreed to this, but eventually this became like they passed constitutional amendments sort of enshrining this process into the Constitution and state law. Is that right?
Right. What they forgot to do, what they neglected to do, because they assumed rather naively that no one would ever challenge it. They did not write the formula for appointing those commissions into the Constitution. 2001 comes along, and the Republicans changed them. Governor Bush at the time was steamed about how the court had been blocking him on capital punishment issues. So was the legislature. And with the legislature and the governor both under the Republican control for the first time, they passed legislation allowing the governor to appoint all 9 members of each commission. Now, the Florida bar gets to suggest people for 4 of those seats, but 4 is not a majority of 9.
Right.
New law also allows governors to reject the bar's recommended lists as often as they like until they get the names they want, or the sort of names they want. Well, that didn't begin to happen until Rick Scott was governor.
Yeah, and let me jump in and before we get to Scott, so under Jeb, and this is right after basically Republicans took unified control of Florida government. This would have been, I think, 98 is when they got complete control, and 2001 is when they made these changes. So it went from the governor had to make his judicial appointments from a slate of nominees proposed by a commission that was comprised of 3 people picked by the bar, 3 people picked by the governor, and then those 6 people together pick 3 other people, and that's where you get your 9 commissions.
That's precisely
right. And then in 2001, Jeb got, first Republican governor since Reconstruction, I believe, got the Republican-controlled legislature to change the law so that.
No, there were two Republican governors before him.
I always forget. Yeah, that's right. I always forget Bob Martinez and Claude
Kirk was voted out, and so was Bob Martinez.
That's right. To win re-election, that's what.
Bob Martinez never tampered with the commissions the way that Jeb and his successors would go on to do.
I can't tell you how many times I've had to write that correction.
He never rejected a list of nominees from the bar, members from the bar, for example, although the bar told me that they did tailor their recommendations to what they thought would be his liking.
That makes sense. And so before we get to Rick Scott, after that change, so now Jeb Bush, the governor, gets to appoint all 9 members of this commission, although 5 he has sole authority. The other
something else very important that happened before then, because of a series of scandals at the Supreme Court, which was really an ethical slough. 3 members came under investigation, and 2 of them had to resign. The legislature, the governor, and the people agreed to put an end to electing judges of the district courts of appeal and the Supreme Court itself. The only way to get there now is by appointment, which put enormously more importance on the nominating commissions.
That makes sense.
Since the governor took over the nominating commissions, they have become essentially what he wants the courts to be.
Right. And so did the change going from elected judges to appointed and solely with merit retention, was that sort of concurrent with the changes to the nominating or the establishment of the nominating commissions, or how did those 2 pieces fit together?
It happened earlier. They created in 1971, Governor Askew created the nominating commissions. In 1972, that was written into the Constitution. In 1976, the Constitution was amended to put an end to contested elections for the Supreme Court and the district courts of appeal. Judges and justices of those courts now stand for election in what are called merit retention. I find something to laugh about with that title in current circumstance.
Right.
So it maximized the importance of the nominating commissions, and above all, why they should have remained independent. They are not.
Right.
Nominating commissions are known to give Governor DeSantis, for instance, exactly who he wants for those Supreme Court seats.
Yeah. Now, so we're about to get to some of the changes Rick Scott made, but just real quick. So after the changes made for Jeb to let him appoint all of the entire nominating commission, did we see much of a change immediately from that on sort of the types of judges getting appointed? Like, was that immediately apparent how significant that change was, or tell me about the effect of that over the next few years?
Jeb only made 2 appointments to the Supreme Court. One of them was one was somewhat questionable. The other one was fully competent. Neither stayed long because they were either unhappy with being in Tallahassee or unhappy with the court. Charlie Crist came along and he applied 4 appointments to make. 2 of them were rank conservatives who'd already been serving for years on the First District Court of Appeal. The other 2 were quite liberal members. He tried to balance it. The 2 conservatives remained for a long time, and one of them, Charles Kennedy, is still there.
Yeah, that's right.
Right. He was, for a time, was the chief conservative in the court. Now the chief conservatives are even more conservative, well, just as conservative as he is, are the ones that DeSantis appointed.
Yeah.
One of Governor Crist's appointees had to retire for age. The other, Justice Jorge Labarca, is still there.
That's right.
I don't know if I can stand it because he is constantly dissenting and everything remaining, principally the death penalty.
Right.
And one of the radical things, this court, that DeSantis court, as I call it, has repealed every precedent that one or more of its members don't like, including the historic commitment they made in 1974 to review every death sentence for proportionality.
Right.
They would try to decide whether that sentence really deserved the death penalty, aside from the question of whether the person was guilty or not.
Right.
Now they've repealed that. And that has, in fact, repealed one of the bases on which the U.S. Supreme Court approved the new Florida law.
Right.
But the U.S. Supreme Court apparently hasn't realized what was done to it or doesn't care.
Right. Now, we'll come back to the sort of the modern DeSantis court in a sec, but so after Jeb made these changes, you started to get into Rick Scott sort of extended the governor's influence over these nominating commissions even further. How did he do that?
He began rejecting slates of lawyers the bar had suggested for the appointments he had to make from among their recommendations to these various courts. I forget the number, but I think there was at least at one point the bar counted 13 times.
15 stands in my memory as a number.
Yeah. He'd reject multiple times over and over, sometimes more than once with the same court. It was made plain that he wasn't going to accept any panel that didn't have some trustworthy right-wing person on it.
Right. And my memory of that is that he would never explain, he would never put in writing why he was rejecting. He would just reject them. Is that right?
That's correct. He never issued a specific objection to any particular person.
Right.
But you could tell what he wanted.
What did he want?
Conservatives who vote the way he wanted them to.
Right. And this is like my memory too is, if you were a plaintiff's lawyer, if there's a plaintiff's lawyer on the list for this nominating commission, someone, that like a personal injury lawyer, that was an automatic rejection, that sort of thing. Were there other kind of clues like that?
Public defenders.
No, of course, that makes sense. Right.
They never got anywhere. So the commissions began to display a very obvious bias for former prosecutors.
Right. Yeah, one of the things I like to tell folks when you're trying to understand the influence of different industries, like the insurance industry, that like for the longest time, one of the main appointees on the panel that nominates Supreme Court justices was the biggest insurance lobbyist in the state, right? Like, I mean, it really is sort of become another pathway of influence for special
It's
interest.
still there, I believe.
I think that's right. Yeah.
And
Okay. Go ahead.
what's shocking about this is that one member of the Supreme Court nominating commission regularly argues before the court, before judges, whom he's helped to select.
Right. No conflict to see there. Did what was the impact of Rick Scott rejecting slates so often? Like, did the bar just eventually sort of acquiesce and start only sending over,
Yes.
corporate defense attorneys, Federalist Society members, and prosecutors, basically?
Now, no, that gets to another extremely tragic distortion of what was done over the years to improve the courts. The Florida bar has been almost mute
Yeah.
in commenting on any of this or dealing with any of this. The one thing it did do was to run a poll every 2 years of lawyers asking for their opinions on the performance of judges on the district courts of appeal and the Supreme Court, that is, those who are coming up for merit retention.
Right.
And that poll was the only useful indication of what we in the media had and what the public could obtain as to the performance and the qualifications, and most important of all, the integrity and fairness of these judges. Well, they started turning sour 2 years ago, and all of a sudden, the poll doesn't appear this year.
Right.
With no announcement, the bar killed it. When we called and asked about it, they find that and noticed that it was not appearing. They said, oh, it had been dropped. They have not come, in my opinion, with one single credible reason for dropping it. Other than that, they're scared out of their pants by the Supreme Court. Now, that's understandable because the bar is an extension of the Supreme Court.
Right.
All Florida lawyers must belong to the bar because it's the Supreme Court that says so. Like some other states that have separate commissions to license and discipline lawyers, the bar is it.
Right. That makes sense.
And so there is no independent voice, non-governmental voice for lawyers to organize and stand up for the independence of the courts. The bar, in my opinion, has become useless.
Wow.
Worthy of respect in that regard. But again, you can't terribly blame them because they are, in effect, an agency of the court. One of the things the court did to them was forbid them from using diversity training as on the job training for judges.
Right.
Or for lawyers.
That's remarkable. And one of the things when I was like a newspaper journalist, and even to this day with the newsletter I'm writing, one of the most common questions I'll get around election is asking about judges. People just looking for some sort of resource from which to like make kind of an informed vote on judges. And this was, to your point, like one of the only kind of resources we had to evaluate the effectiveness is this poll of lawyers about sort of these judges, and now that's gone too. So you're just completely flying blind in so many of these elections, which drives to, I think you were alluding to this. We call them merit retention elections, but they're just automatic retentions now because
nobody's ever been turned out, and several should have been.
Right.
Now, 2 years ago, two of DeSantis' justices got pretty low grades, like better than 50%, but at the level of say 60% would get you flunked in most
right.
high school and college courses. And I was reasonably sure that if they had conducted the poll this year, there would have been less than 50% recommending the retention of Meredith Sasso and Renata Francis, the two recent most political appointments. Well, they're most political than some of the others, but I think that's why the poll was dropped. The bar was afraid that how it would come out.
Right. And so let's now move ahead to the DeSantis administration. So we had Jeb essentially got the legislature to give him the power to appoint all of the nominating commissions. Rick Scott started pushing the envelope even further by rejecting even nominations that for the nominating commission that he didn't like. And so putting even more sort of governor's influence on this process. How has it evolved even further under Governor DeSantis?
It got to the point where the bar was having trouble getting lawyers to volunteer to serve in the nominating commissions. if I were a lawyer, I'd say, look, there's a rather detailed application I have to fill out. Why should I bother when I know that, excuse me, that I'm because I'm a Democrat or a trial lawyer or somebody who just has a healthy respect for the independence of the courts, that I'm not going to get appointed to this commission. It got so bad that one lawyer applying for the last Supreme Court vacancy, said directly to the nominating commission, look, everybody knows you're going to pick someone whom he wants. And everybody told me, why bother? Well, right. I'm bothering, but she didn't expect to get nominated. And of course, she wasn't.
Right. And that strikes me as so important is you can't just sort of like give in to this sort of stuff. You probably should bother even if it seems pointless, because otherwise, it would feel like, I mean, there has to be some sort of resistance to just sort of totally like abdicating, even if it ultimately is futile. You still have to wage that fight, I would think.
Well, when one of the most recent Supreme Court seats came open from resignation, only 3 lawyers applied for it. One of them was somebody that everyone knew the governor wanted to appoint. Another of them was legally, constitutionally ineligible. So the commission would not have been able to present him with the required 3 nominees. So they had to reopen the search. And of course, it still came out the same way.
Right.
Meredith Sasso was the one he wanted, the one he got.
Right. And by the way, and just to how incestuous this is, Meredith Sasso, who's, I don't know if it's husband or father-in-law, also serves on one of these nominating commissions on a court that she used to serve on too. It's just the incestuous nature of this whole process, the way this has evolved is just remarkable.
It does not look, smell, or sound very good, but that's what Florida has. I have to tell you that if the people who endorsed Merritt's selection of the higher courts had foreseen this in 1976, it never would have passed. And in a recent editorial, I raised the question, could electing justice be any worse? There are terrible things wrong with election, but at least the people have a say in that.
Right.
They don't have a say now.
Yeah, it's interesting because you see this in other states. I'm not super familiar with this, but like, Wisconsin, Michigan, North Carolina all come to mind as places where Supreme Court justices are elected. They've just become, in one sense, I think like they have become just purely partisan elections, right? People are, you have the parties taking clear sides, and they're just like, they're as intense almost as U.S. Senate races now in some of these states.
That has happened in North Carolina, where a heavily gerrymandered Republican legislature did 2 things. It made judicial elections not partisan again. They were all running as nonpartisan, the way the judges in Florida do, and canceled the voters' guide that it made available to the public to tell the public who these judges were, or these judicial candidates were. Now, we just had an extremely close election here where a Democratic incumbent on the Supreme Court, whom Governor Cooper had appointed, was trailing on election night, but when they got around to canvassing and counting all the mail votes, she was ahead by some 600 votes.
Oh, wow.
The Republican has filed enough lawsuit to challenge 60,000 of hers. It'll be very interesting to see if that gets to her own court, which has a Republican majority. But for now, she's ahead. Wow. But that's how close it got.
Wow, that's remarkable. So I actually want to put a pin in this idea of potential reforms. But first, you started to allude to this. Like, one other thing we didn't actually talk about was another thing that Ron DeSantis started doing, and I think this is new to him, although maybe we just didn't know about it under Rick Scott. He has acknowledged that he's got like, in addition to controlling now these nominating commissions that are supposed to like essentially handpicking everybody that serves on this, the people that are supposed to screen the nominees and put some sort of collar on who the governor can appoint. He's got his own like secret panel of people that he uses to vet, with Leonard Leo, famously the chair of whatever this secretive panel is. And the governor has never identified who else is serving as his kind of off-book advisors and screeners on judicial appointments. What do we know about that?
What we know is that he refuses to identify any of them. We do know Leo. He's pretty much, but identified by two former justices who had to divulge that to the U.S. Senate Judiciary Committee in order to get to confirm to the 11th Circuit Court of Appeals. He, but he refuses to say who they are, and in defending himself against a lawsuit that called for him to honor the public records law, which he despises, and identify them, he claimed he has sovereign immunity to
executive privilege.
Executive privilege to refuse to divulge anything he doesn't want to indulge. Well, that takes up the Florida Public Records Law and just rips it in two.
Right.
The First District Court of Appeal, which is another court under his thumb, upheld his refusal, but did not reach that point. Did not reach the point that the trial judge found for him. They said it was irrelevant, that the case should be dismissed on jurisdictional grounds. And so there is at present no ruling upholding his claim to executive privilege, but he's going to do it again.
Yeah, that's right. There's also no ruling sort of saying it doesn't exist. So he's going to continue invoking it until he's told that he's not able to, right?
Yeah, he also says laws don't apply to him.
Right.
And
part of the reason I bring this up is just to sort of enforce for people or reinforce for folks why you ultimately this stuff matters. Because this goes back to a bit about what we're talking at the beginning is, so we've got a situation where the governor of Florida is inventing a claim of executive privilege that appears nowhere in the Florida Constitution or in state statute. It's basically just trying to copy something that the president can invoke and try and take it in Florida. And by invoking executive privilege, essentially completely exempt himself from public records law when he wants to.
Exactly. And I have to say that Florida's Attorney General, Ashley Moody, has been his henchperson in doing that.
Remarkable.
For many years, Florida attorney generals aggressively enforced and supported the public records laws.
Right.
Pam Bondi was the first who didn't. And of course, now she's supposed to become Trump's attorney general.
Right.
And Ashley Moody has been an absolute total disgrace as attorney general, as far as I'm concerned. And her indifference, indeed her hostility to the public records law, to Florida's entire concept of government in the sunshine, is one of the reasons I say that.
Yeah, that makes sense. But you're in this situation now where, so if the governor is claiming this executive privilege and it doesn't exist, the only way to arbitrate that is through the courts. And if you've got ultimately, if you have a Supreme Court that is more sort of beholden to the governor and only interested in helping the governor, whatever he says the law is becomes the law if a court is unwilling to challenge him. And so it sort of speaks to this, goes to the point like earlier we're talking about how he invented this idea that he's immune from this law barring state officials from campaigning, which another, by the way, Ashley Moody made that argument for him in briefs, like just a wild thing for the attorney general of the state to position for her to take. Again, that ultimately has to be resolved by these courts, right? And so, I mean, it just really shows, it really articulates just how dangerous it gets when you allow the courts to become so intertwined with the politicians they're ultimately supposed to be serving as a check on.
Exactly. I said that some of these judges, some of these justices will be ruling the way they are, regardless of who the governor was, because they are just hard right-wing radicals to start with. Mm-hmm. But they're certainly going to do what he wants. And in a constitutional democracy, the only protection the people have against authoritarian, even fascist government is the willingness of the courts to defend the Constitution. Florida courts won't do that any longer.
Yeah, that's remarkable. Okay, so let's get to this idea of, of what could be done to reform it. You mentioned, I mean, potentially like maybe this is just a pendulum swinging thing back and we've got to go back to elections, until that becomes a problem again. But are there other ideas, that setting aside the likelihood of this governor and legislature passing them, what are some of the ideas that you think could sort of restore credibility to the system?
I really would not want to, nor recommend going back to elections, because they are all very likely to be controlled by people with the most money at stake and the most money to give. And that would be, of course, the insurance industry, the big industries that don't want to be held accountable for hurting people. The single best thing that could be done, and I would set it right very quickly, is to go back to the system that Askew created for nominating commissions that neither party could control.
Mm-hmm.
Neither the bar nor the governor could control them. I came across one instance where the governor appointed a non-lawyer and a Republican to the Sixth Circuit Nominating Commission, prompting a spiteful response from the chairman that how dare he appoint a non-lawyer to a commission that's supposed to interview lawyers as to whether they thought other lawyers were qualified to become judges. Of course, this is something editorial boards did all the time, so I wasn't too enamored of the chairman's letter. But I know why Askew did it. He did it because he could trust this lady, Sally Wallace of St. Petersburg, to not be partisan and to put down partisanship whenever she saw it. And I was aware of that letter when Kurt Kaiser, who had been a Republican member of the legislature, told me they had gone to Askew complaining that two Democrats, the only two elected Democrats in Pinellas County, the circuit clerk, and the sheriff, were pulling strings with the commission to block Republican applicants for judgeships. And he said the governor told him, Kurt, I'll take care of it. Just let me take care of it. And Kaiser told me, I don't know how he did it, but he did it. He stopped that. Well, I know how he did it. He did it by putting Sally Wallace on the commission.
Right.
So that explains what a governor can do to keep the commissions honest, but it also illustrates what he can do to corrupt them.
Right, right. Yeah, it's interesting. I just had a long conversation with Mary Ellen Kloss about some of her findings with the way one party, states dominated by one party, how like unresponsive they've become to voters and how like basically they backslide on all sorts of democracy metrics, like right down to competitive elections and stuff like that. And ultimately, like the reforms we landed on, or the reforms that come to mind, they almost all involve the people benefiting from the current system voluntarily giving up some of their own power. And, at least, and to my mind, it seems like an impossible thing to ask of the people we have there. But like looking back at this historical example, you actually had a governor who did voluntarily give up some of his power in the name of good governance.
Gave up a lot of his power. As I said, that McFarland at the Florida bar said it was the most unselfish thing any governor ever did. No, the only way to get the legislature in Florida will never put things back as they ought to be. That could be done by an initiative, but you know how difficult initiatives are, and initiatives cost a lot of money. Who's going to contribute the millions of dollars it would take to, one, get this on the ballot, to persuade the voters to approve it by 60% or more.
Right.
That's why I don't hold any hope for Florida's future, so long as they keep electing governors who don't believe in democracy.
What has to happen, I think, is a Democrat has to get elected governor, because then what you're going to see is the legislature rush out a bunch of laws to weaken the powers of the governor. And so that might be the ticket that gets the governor with less influence over these processes.
I think if a Republican legislature became afraid that a Democratic governor would start appointing honest people to the courts, perhaps they might make a change. But that depends on the condition precedent being the election of a Democratic governor.
Right. We may as well hope for the current politicians to willingly give up power. That seems more likely at this point in Florida. So, well, thank you for doing this. I appreciate it. I think that history lesson is important because we've got so many folks in Florida, especially with term limits and stuff, that folks that just don't know any of this history. I guess the last thing I'll ask you, you did start to allude to this, is just how extreme the current Supreme Court has come. When you think of other ways, you mentioned some of the death penalty stuff. Are there other ways that come to mind that that illustrate just sort of how much the court is swung or how extreme it's come in your mind?
Well, yes. The original and strict test of whether a court is conservative or not is whether they respect precedent and whether they say as little as they need to decide the case before them. Well, the U.S. Supreme Court has long since cast those principles aside, and so has the Florida Supreme Court. They've rescinded principal precedents that had to do with how evidence is received, how the courts are run. The most conspicuous retreat was in the death penalty. And there's quite a few other instances in which they have repealed precedents of fairly recent vintage. Yeah. Moreover, they do this on their own motion without even a case before them.
Right.
We'll open a docket and you can comment on this. Well, what's the point?
Right.
When they banned diversity education from in-service training, that was a case in point.
Yeah, sorry, go ahead.
There were almost 60 objections filed to that decision having to do with diversity, right, including one filed by Deborah Wagner, a former colleague of mine, a lawyer in Florida who had been the staff of the Florida Supreme Court's Commission on Gender and Racial Bias back in the time when the Supreme Court cared about those things. And she was one of those who protested how Florida's legal ranks and courts had become riddled with bias, right, often unconscious bias. And that's the real problem. People don't think they're biased, but they act as if they are.
Yeah, right.
She was one of those who filed a very, very eloquent objection. It was ignored completely.
Right. Yeah, when you think of, there's another one that obviously comes to mind is, they completely overturned the precedent that Florida's right to privacy clause includes the right for women to make private personal decisions about their own bodies, right? And that abortion was not covered by the right to privacy.
Right, that's the big one. I mean, it would have been possible for them to uphold the earlier anti-abortion law, which on limit was 12 weeks. It would have been possible to rationalize that was consistent with an evolving understanding of viability. But they went beyond that.
Right.
The only thing they didn't do in that case was accept Bondi's horrible argument that the right to privacy means only the protection against having governmental documents.
Right. Right.
Informational privacy only, she said. That would have absolutely undone everything the Supreme Court has done in the area of end of life decisions.
Right.
That's still vulnerable, but they didn't quite say that.
Right. You raised another really interesting point too. There is, I feel like I'm seeing more and more signaling from the court where, like, in their opinions, they seem to be inviting the legislature to do stuff. Like I'm thinking of, when they put
they pretty much wrote a roadmap for what the legislature to undo the abortion amendment had it passed.
Right. Yeah, that's right. That's part of what I was thinking of, is that there was all these concurring opinions where they were basically inviting the legislature to pass a personhood law, a fetal personhood law. And then, we've seen it even, there was, I think this was Justice Kennedy, who you mentioned earlier, wrote a dissenting opinion in a case involving a corporate polluter law, where he basically invited the legislature to change the law, to protect corporate polluters. Like, I mean, this covers the gamut of stuff. And there's just, we were talking earlier about the sort of like the blurring of the lines between the executive and the judiciary, but there's also increasingly a blurring of the lines between this judiciary and the legislature, right? Where, they're working in tandem to write laws, it sometimes feels like.
There's no line anymore. It's an open house.
Right. Well, at least Ruben Askew gives us maybe hope that things could change one day. So
yes, but he's in his grave. I'm glad he didn't live to see the worst of this.
Yeah. Well, Martin Dyckman, thank you for doing this. I appreciate the history lesson, and the context you bring to all this is really valuable.
And thanks for letting me get back on my soapbox, because this really matters.
Anytime. Yeah, this is incredibly important.
To me. Personally heartbreaking.
Yeah, I can see that. Well, listen, I suspect we'll have more reasons to get back up on soapboxes out here, unfortunately. So maybe we can do it again. Thank you again for your time.
Thanks a lot. Bye-bye.
Okay. Thank you once again to Martin Dyckman for joining the show. We covered a lot of ground in a short period of time there. So I'll throw a couple of stories he's written over the years about this stuff into the show notes. You can read more about it if you want to see it more in chronological order, that sort of thing. Before we go, just a reminder, click those like and subscribe buttons, and make sure to leave any comments below. And we'll see you again soon.